This is the Insurance Law Podcast, brought to you by Best Recommended Insurance Attorneys.
Welcome to the Insurance Law Podcast, the broadcast about timely and important legal issues affecting the insurance industry. I'm John Zuba, Managing Editor of Best Recommended Insurance Attorneys, including expert service providers. We're pleased to have with us today Jerry Birnbach, Fellow in the Institute of Store Planners and Associate Member of the American Institute of Architects, from Jerry Birnbach and Associates in Somers, New York. Jerry is one of the few retail experts in the insurance and legal fields. He has 35 years of experience on award-winning store and display design, working with Fortune 500 companies, and his website, www.expertretailwitness.com, helps eliminate the risk in store design. He also has served as an expert witness in no less than 70 cases. And Jerry, we're very pleased to have you with us today.
Well, it's my pleasure to be with you.
Thank you, Jerry. And today's podcast discussion is on slip and fall matters and what companies and defense attorneys need to be concerned about during the litigation process. And Jerry, for today's first question, how can any government regulations or industry restrictions ensure satisfactory customer service in a store or business?
Well, currently the regulations call for a retailer or a public assembly area to provide within itself a reasonable level of safety, and it needs to be hazard-free. The issue of retailers trying to put this all together winds up where their training and their manual guidelines have to address all of the various considerations that go into making a store safe. The way that customers achieve safety is by not having obstacles and interference placed in front of them. So it's up to the store to make sure that they're patrolling the stores and especially the floors to make sure that they're safe. Now, what constitutes safe really is a lot of specific detail. There appears to be industry standards that the retailers follow in order to relieve themselves of the liability of being held responsible for an injury at store level. It's an industry that's not very regulated in terms of statutes that you can turn to that say, aha, that's something they failed to do. It basically comes down to creating manuals and safety regulations protocol and then calling upon the store staff and employees to follow them precisely as they're written.
Jerry, what specific type of regulations can have major bearings on or impact a case?
Well, the issue regarding regulations is, as I mentioned, there are very few that are out there that are dictated by law. You can turn to the American Disability Act, which has probably got the greatest influence when it comes to store matters and slip and fall. And, I just can't stress enough the fact that this is an industry where it's more about what the industry has considered the optimum level of compliance in terms of the store's requirements. There really is some characteristics that lead to the majority of these incidents and injuries, and when it comes to a retail environment, most of the items are caused by either overloading the carts that move the product or abandoning the carts and leaving pallets on the floor. Liquid on the floor is certainly one of the great slip and fall matters, and the fact that retailers are trying to get every dollar out of their square foot winds up where they get innovative and start to reduce the aisle width in order to get more product in, and in doing so really creates some big issues in terms of liability. Proper maintenance is something that needs to be maintained at all times and actually documented so that you can show that you're being compliant and you're doing your best to keep the customer safe. When you get to other types of public assembly, like a hotel lobby, one area that gets a lot of action is where they give the coffee out, and there's a lot of issues regarding that, whether it's slip and fall or burns, that really is regulated and controlled if you can make sure that your staff is compliant in terms of making sure that everything is in its proper location and being maintained at all times. It's just something that has to be entrenched in their heads, that it's something that needs to be done at the time frame in which it's dictated to be done. Lastly, in an office lobby, that normally becomes an issue regarding floor care, lighting, and maintenance policies, and all of these do need to be in place and accurate and well specified to avoid any questions later on.
What types of practices can you suggest that stores might be able to adhere to in order to eliminate any such risks in their particular establishments?
Well, one of the big responsibilities of a retailer is to inspect the aisles. Many retailers actually define the time frames in between inspections, and it really is beholden onto the staff not to be as concerned about inventory, which they normally are, but to give attention to issues such as displays out of place or product out of place, because all of those can lead to some disastrous types of injuries. Floor inspection, as I mentioned, is probably the biggest issue and where a lot of attention needs to be spent, not only on the maintenance side, but also the patrolling and making sure it's always clean and free of any kind of foreign matter. The issue in the regulation also stipulates that it's not enough just to inspect, but you also need to be sure that if there is a spill, that it's cleaned up correctly. And there needs to be ways in which you can move your product throughout the store in a safe manner so that it doesn't fall on someone. It shouldn't be abandoned, because there's a tendency for customers to want to try to shop items that are parked next to a display when in fact they're unstable and they could lead to injury. And the management of the safety is a bottom line issue, and most retailers tend to not place as much emphasis on it, but it basically is where they're going to take a big hit if they're involved with a large lawsuit due to an injury and the responsibility was theirs.
And Jerry, what organizations could be the most influential in slip and fall cases?
Well, as mentioned before, that it's an industry that's not very regulated, and it happens that the building itself falls under the building code or the local building codes, and for the most part, most of America follows what's known as the International Building Code, which is taken a long time to formulate, but the good news was that it's standardized building code regulations, so at least you're able to learn it and obey it and not have to worry municipality to municipality. So that is one area that has a little bit of impact in terms of what's going on in the store and creating a safe environment. The next one, which is a little bit more critical because the building code actually adopted it, is the American Disability Act, which was intended to regulate and protect handicapped individuals. But what most attorneys are not aware of is the fact that that really is regulating America. You don't have to be handicapped in order to fall under compliance. It's expected of every retailer to be following this act, and in doing so, whether you're handicapped or not handicapped, the retailer needs to be abiding to these particular regulations, which really address safe dimensions and methods of construction and certain materials that need to be applied in slip areas. And then the last one that has impact would be OSHA, which is the Occupational Safety and Health Administration. And their responsibilities are to make sure there's a safe working environment. And it's taken a long time for that to kick in, but it's a very well-run organization within the federal government. And their focus really is to make sure that employers are providing a safe environment for the employees, and in doing so, it also affects the customers who are shopping. And some examples would be to make sure that your ladders are safe and that you're keeping mechanical equipment or maintenance machines or service machines off the floor because they can lead to trouble if somebody touches them or accidentally runs into them. And for the most part, they address displays such as pallets, which is probably the only element in the store that they do address in terms of whether it needs to be completely loaded because there's a visual issue that goes along with it in terms of liabilities. People aren't normally looking down at the floor when they're shopping, and the retailer is basically throwing so many elements at them at eye level that they're not expected to be looking at the floor, and an empty pallet is hard to envision or see when you're shopping, so it's regulated not to be empty. And those would be some of the major elements in organizations that do impact the slip and fall in the retail area.
And what's your advice to a business or their defense attorney when trying to defend in a slip and fall case or to eliminate the possibility of risk?
Well, that's a really good question. The reality of what's going on with slip and fall is that when it comes to retail and some of the public assemblies, the law is just asking you to not have to put a shadow behind every customer or occupant in the area. It's asking you to make sure in a reasonable, and that's the key word, reasonable manner to maintain a safe and hazard-free environment. And in doing that, the major organizations like a Walmart, Target, and Wegmans and Kroger's, they've all determined what they would consider reasonable and willing to fight in court against. And the issue that I find time and time again is that the corporation is great at putting these manuals and protocols and procedures together, but where it's falling apart is at store level or in hotel staff members, and the problem is that they're not complying with what the company is asking them to do, and they're not documenting it correctly, and they're not following the protocol and procedures that they're being asked to follow. And when they do that, they put the corporation in harm's way. And it's really behooving done to the attorney on the defense side to really hit home the fact that they really have not much to work with when you're dealing with obvious surveillance that shows all of these violations and disregard to what's being asked of them to do. So I think the major and have would be to tell them to enforce and make sure that management at store level is really overseeing their stores correctly.
Jerry, thank you so much for joining us today.
It's my pleasure. Thank you so much.
That was Jerry Birnbach from Jerry Birnbach & Associates in Somers, New York. His website, again, is www.expertretailwitness.com. And special thanks to today's producer, Frank Volwinkle. And thank you all for joining us for the Insurance Law Podcast. To subscribe to this audio program, go to iTunes or our webpage, www.ambest.com/claims resource. And if you have any suggestions for a future topic regarding an insurance law case or issue, please email us at lawpodcast@ambest.com. I'm John Zuba, and now this message.
Best Insurance Professionals and Claims Resource is the top website for locating qualified professionals and need-to-know insurance information for the claims market. Brought to you by AM Best, the world leader in insurance industry information. Visit ambest.com/claims resource.